All right, well, legal counsel for the Public Protector, Advocate Dali Mpofu, says that the rules of the National Assembly on the removal of his client from her position are unconstitutional because they seek to amend the Constitution. The Western Cape High Court has begun hearing Public Protector Busisiwe Mkhwebane's challenge against Parliament's impeachment rules. The matter has been set down until Friday. In October last year, the court dismissed Part A of Mkhwebane's challenge, which was bid to stop her removal proceedings. This paved the way for Parliament to establish a 36-member committee to look into the advocate's fitness to hold office. Today, as part of Part B of her application, she wants Parliament's new impeachment rules to be declared unconstitutional and invalid. The motion to impeach Mkhwebane was brought by the DA. All right, well, our reporter Bulelani Philip spoke to the Public Protector's Chief of Staff, Busisiwe Mkhwebane. He's outside Parliament. We cross live to him now. Very good afternoon to you, Bulelani. Of course, I do understand at this stage that the legal representation for the Public Protector wants her to indeed be able to have further legal representation into her inquiry. Talk to us about what's happening. Talk to us through the proceedings. I also do understand, on top of that, that there is a possibility or a want from those defending the Public Protector that this even heads to the Constitutional Court if needs be.
Well, good afternoon to you, Flo, and to the viewers. Of course, it's going to be a marathon of a hearing between Parliament as well as the Public Protector. Of course, this is the first for the country, as Parliament last year in December adopted rules that would be able parliamentarians to remove any head of a Chapter 9 institution. But particular focus has been on the head of the Public Protector's Office, which is Advocate Busisiwe Mkhwebane. Now you'll realize that this case now comes here in Part B. Part A wanted to interdict Parliament from proceeding with the inquiry into the fitness to hold office of Advocate Mkhwebane. Now Part B, which began today, is about the merits of the case and why she argues that this case is unconstitutional. Now, one of the issues that has been brought by Mkhwebane through her legal counsel, Advocate Dali Mpofu, is that Parliament is allegedly denying Advocate Mkhwebane from having legal representation during the inquiry, and she believes that that is a change of her constitution and also it infringes on her constitutional right. And secondly is that she argues that she shouldn't be charged under these new rules that have been adopted by Parliament, because those rules are just a copy and paste of an impeachment process of the president, and her office is akin to that of a judge, and then therefore she prefers that she be charged under the impeachment process of judges. So as we stand now is that it's going to be the Public Protector that is going to be leading arguments up until on Wednesday, and then Parliament will then therefore respond to the arguments of the Public Protector. And on Thursday and Friday, we expect that her supporters, through the Democracy in Action organization, which has been doing fundraising for her personal cause order, are those the respondents that will be arguing on Thursday and Friday. Flo?
Let's just get some clarity here. Advocate Dali Mpofu, SC, was speaking, obviously, of course, on her behalf as part of her legal team. And just to get back to that point that you made about the fact that the rules of Parliament preventing an impeachment process from going ahead against the Public Protector, what did the Advocate Mpofu rely on when he was speaking on this? I mean, it says these are the rules of Parliament itself, so Parliament should essentially itself be very aware of their own rules. But I wonder if on the back of that, there are other rules or other pieces of legislation that perhaps the Advocate was using in terms of relying on.
Flo, I think let's take it back to last year, February, when the DA made its initial motion for the removal of the Public Protector. Parliament at that stage did not have the rules for the removal of any head of a Chapter 9 institution. It was then, therefore, quite important that Parliament actually has a framework, a legal framework for the removal of any head of a Chapter 9 institution. Now, the DA actually had to withdraw that initial motion after, the realization that Parliament didn't have specific rules for the removal of a head of a Chapter 9 institution. Mm-hmm. Now, Parliament went through a process, formulated the rules, and when those rules were adopted by the National Assembly, then the DA went back to the National Assembly and reignited that process of the motion in the removal of the Public Protector. That was approved in December last year, and Parliament now only duty was to actually ensure that it actually has what is prescribed in those rules, to have a committee that is composed of experts that are independent from parliamentarians that will determine whether there is prima facie evidence in the removal of the Public Protector. Now, that panel of experts actually came to the conclusion that there is a case to be made in the removal of the Public Protector, which report was brought to the National Assembly, and now the National Assembly, its next step was to actually formulate a panel of a multi-party committee that will then investigate, one, the report that was tabled by that report of the independent panel, and two, give the Public Protector an opportunity to respond to some of the allegations that are in that report, as well as the motion that has been brought by the DA. So that process now, it's still at the committee level, and if the case at least goes in favor of the Public Protector, it means that the parliamentary process will have to stop. But if it goes against the Public Protector, then it means that committee will then have to proceed with its work. Flo?
Yeah. All right, just in closing then, where are we now? I understand that this will be heard, we've got the whole week basically until Friday, and we understand that there's 3 judges indeed that are hearing the application at this time. What next are we expecting?
Well, Flo, for the next 3 days, including today, it's that the Public Protector's counsel, Advocate Dali Mpofu, will be the one who's unpacking the case of the Public Protector. And then on Wednesday afternoon, we expect that Parliament will be responding to the arguments of the Public Protector. And then other respondents, including some of the amicus curiae respondents, which also include some of the supporters of the Public Protector, which is the NGO Democracy in Action, will also outline why they feel that it's unfair and unconstitutional to institute removal proceedings against the Public Protector. Flo?
All right. Bulelani Philip, thank you so very much for that update. We'll certainly be catching up with you throughout the week to get more information, certainly on this particular case. Thank you. All right, that's Bulelani Philip for us in the Western Cape. He's in fact just outside Parliament there, and following up, of course, on the Public Protector's Part B application, which is being heard from today at the Western Cape High Court. Mkhwebane challenging Parliament's rules of impeachment.